This is Chris McKaylee with a video podcast on the statements that are included with urgency statutes and special statutes. Now, California courts on occasion are faced with scrutinizing lawmakers' decisions to label some bills as an urgency statute and others as special statutes. Now, while these may seem kind of unexciting topics, at least for non-legislative geeks, you know, courts' rulings in these types of cases could potentially affect thousands, if not millions, of Californians. So there are statements that are used in bills to justify an urgency statute or to justify a special statute designation. And in the rare instances where the courts review these statements, they're basically deciding whether the legislature has provided a sufficient enough explanation or justification for either that urgency designation or that special statute designation. And how lawmakers define their bills, the courts are going to evaluate them on those statements contained in the bills. Now, you may be aware an urgency bill requires a two-thirds vote in both houses for approval and will take effect immediately upon enactment. And these bills typically deal with things like taxes, elections, appropriations, and other types of measures that are necessary for the immediate preservation of the public peace, health, or safety as the Constitution sets forth. A special statute, on the other hand, is essentially a law that applies to a particular person, place, geographic location, or interest. And these bills typically don't draw a lot of public attention because they are more of a district bill in nature, if you will. And the special statute designation is distinguished from the general statute, which is what most bills are and what most people are familiar with. A general statute is one that's essentially pertaining uniformly to an entire community or to all persons generally. Per the Constitution, the legislature can enact a general or a special statute. Now, when it comes to deciding whether a bill is an urgency statute or a special statute, the California courts look sometimes beyond the statements that are contained in the bills that set forth in a plus section, an uncodified provision to justify that urgency statute status or the special statute status. Now, it's imperative that the authors of those bills assist the lawyers at the Office of Legislative Counsel, who obviously write the formal text of our bills and amendments, to provide them sufficient information in order for the OLC lawyers to craft these bills with language that is sufficient for the courts to uphold these designations. Now, they ought to be concise but thorough explanations to provide the justification or the basis for that urgency status or that special statute status. I think that without sufficient justification, these bills could be in legal jeopardy in terms of those designations. Now, both urgency statutes and special statutes are constitutional grants, both of which are found in Article 4 of the California Constitution, dealing with the legislative branch of government. And obviously, these designations are properly subject to judicial review by our state courts. Because of this review, legislators, in my mind, should make it as easy as possible for the courts in the state to understand the intent of the legislature and why they're trying to so designate these bills. I think that if there's insufficient justification, then a court may not uphold that designation despite the intent of the legislature. In other words, just because there's a short statement in a plus section and in uncodified language that says, here's why it's an urgency statute or a special statute, doesn't mean that the courts will blindly accept that language and automatically agree with the legislature. So rather than force the courts to make an educated guess or infer what was intended, I think that lawmakers would help themselves by setting forth thorough and clear explanations of why an urgency statute is required, or in other instances, why a special statute rather than a general statute is necessary. Now, to be fair, our legislative branch of government is obviously the lawmaking branch. But in order to properly fulfill its role, I think the legislature has to make the declarations required by the Constitution, but do a sufficiently good job in providing those designations. With an urgency statute, they'll generally see, or you as a reader will generally see language that says, this act is an urgency statute necessary for the immediate preservation of the public peace, health, or safety within the meaning of Article 4 of the Constitution, and shall go into immediate effect. The facts constituting the necessity are, and then the OLC lawyers will set forth that language based upon what is provided by the bill's author. Now, it's really up to the bill's author to provide legislative counsel attorneys sufficient language. And unfortunately, these clauses are often pretty short. For example, I found one in the recent 2022 legislative session where it said, in order to pay judgment and settlement claims against the state and a hardship to claimants as quickly as possible, it is necessary for this act to take effect immediately. I would respectfully submit that more explanation or justification should be contained in that declaratory statement. I'm not sure that the courts across the board are going to accept a simple one sentence. They may look for evidence to justify that statement. In other words, is there something that could be objectively verifiable that there is hardship to claimants and that judgment and settlement claims, for example, are not being paid as quickly as possible, etc. And so rather than force judges to engage in further research, I think they could simply include in the statement the backup or the evidence for that statement. Now, turning to the other type, a general statute, again, is one that pertains uniformly. And under the constitutional prohibition against special legislation, all laws are general in nature when they apply equally to all persons in a class, founded upon some natural, intrinsic, or constitutional distinction. And the California Supreme Court, way back in 1891, in the case of City of Pasadena versus Stimson, said, a law is special if it confers particular privileges or it imposes peculiar disabilities or burdensome conditions in the exercise of a common right upon a class of persons arbitrarily selected from the general body of those who stand in precisely the same relation to the subject of the law. Now, the general test for determining whether a statutory classification violates the constitutional provision that a local or special statute is invalid in any case if a general statute can be made applicable is, according to the courts, similar to that used to determine a statute's constitutionality under the Equal Protection Clause. The Court of Appeal in 2014, in the case of Law School Admission Council, Inc. versus the state of California, the appellate court said that the constitutional prohibition of special legislation does not preclude legislative classification, but only requires that the classification be reasonable. So after the general statement, a bill contains an explanation of the special nature of the proposed statute and why a bill of general application will not work in those particular circumstances. And so here is language that I saw from the 2021 legislative session in California. The unique island location of Coronado and its proximity to large military installations requires a special law. In addition, the complexities of amending a general plan and a local coastal plan for the city of Coronado will take significantly longer than 6 months, and as a result, a general law cannot be made applicable. Here too, I think that there could be more explanation contained in this declaration. I'm not sure a court is going to accept without any further information those two brief sentences. They might look for further evidence to justify these statements, whether or not being close to a large military installation actually requires a special law, and is the fact that a general plan or a local coastal plan may take longer than 6 months something that makes it particularly unique. So from my perspective, rather than forcing state judges to engage in further research in order to possibly justify these legislative statements, why not have the legislature in these bills simply include the additional backup or evidence? You know, it's been more than 100 years that California courts have entertained challenges to the legislature's attempts to designate things like urgency statutes or special statutes. Now, to be fair, some courts in the state have deferred entirely to these legislative declarations, and in other instances, they haven't accepted them, which is why I think the best approach is for bill authors to provide plenty of explanation or justification in order to ensure that the judicial branch is going to accept the intent of the legislature and how it has designated these bills.